Finally, we take up the question of application of the CISG to international sales. And we have to start with this issue of when does the CISG apply? When does the CISG apply as opposed to one of the other two contracting systems, the common law or the UCC? There have to be three conditions that are met for the CISG to apply. First of all, the contract must be for the commercial sale of goods. So it has to involve a good. A good is a tangible, movable item. We said a good is a product that you can pick up, you can move, you can touch. It's not a good if it is intangible, stocks, bonds, intellectual property, land is not a good. So it has to be a good. The contract for the commercial sale of goods. What's commercial mean? The CISG is different than the UCC in this respect. The CISG only applies if the buyer and the seller are both in the business of conducting those types of sales. You must be a merchant in order for the CISG to apply. If you have a jewelry shop in downtown Stillwater and you buy gold from Turkey, from a Turkish dealer of gold jewelry, those contracts are going to be met, but are going to be governed by the CISG. If the contract is for personal use, non-commercial use, family, household use, then if it's a good, the contract will be covered by the UCC. Or if it's not a good, it will be governed by the common law. So only the commercial sale of goods between parties whose places of business are in different countries. So it's got to be a good, it's got to be between merchants, and those merchants have to reside in different countries. If they reside in the same country, the domestic sales law is going to apply. In the United States, that's the UCC. And the third element is the parties' places of business have to be in countries that have ratified the convention, that have accepted the treaty, that are member states. And as I said, that's a lot of states right now, 84. And for the purposes of this course and your test, whenever I mention two countries, you can be assured that those countries are both members of the CISG. So both countries, members of the CISG. That's the third element. For purposes of the test, we're going to be focusing on those first two elements. Now, there are sales that are excluded, international sales excluded from the CISG, and one is, based on the definition we just learned, anything sold for personal or family or household use. If I am an electronics dealer and I buy TVs from Japan, those are going to be covered by the CISG. If I am building a big house and I'm going to want 30 TVs from Japan, a large order of TVs, doesn't matter. If it's for household use, it's not going to be governed by the CISG. Goods bought at auction, those are special rules apply to goods purchased at an auction. As I mentioned, stock, securities, negotiable instruments, money, all of those transactions are not goods and therefore don't fall within the CISG scope. Ships, vessels, or aircraft, those are large items that are so large that they have their own body of law that is attached to their sale. So any large vessel, ship, aircraft is going to be not governed by the CISG. Electricity, another item that is not a good. Oil would be a good, but electricity, not. There's other types of sales that are excluded from the CISG. assembly contracts, contracts for the manufacturer of the sale of goods, for the supply of goods to be manufactured or produced. An assembly contract is not a sales contract and therefore are not a sales contract within the scope of the CISG. Now this is an interesting point here. Contracts that are in preponderant part for the supply of labor or other services. And this is one you should focus on because, again, I'll ask a question about it. And what this says is that if the contract is mixed in nature, if the contract involves both the sale of goods and the provision of services, only one contracting system can apply to that contract. So it's going to be either the common law or sales law. Now the UCC is not clear on which would apply, but the CISG tells us that in any of those mixed contracts, what we're going to be looking at is what is the contract about? What is the preponderant part of the contract? And the shorthand for yourself and for courts as well is how was the contract amount allotted? If, for instance, I'm building a new classroom building and I want to, or say I'm renovating the classroom building, I want to take out all the chalkboards and I want to replace them with electronic smart boards, and I contract with a company in Finland for the purchase of those boards, and the contract, say, is for $50,000, $10,000 of which will cover the boards, but $40,000 of which will cover the installation. Because the labor is the preponderant part of that contract, it's not going to be governed by the CISG. If the opposite were true, if $40,000 of the amount was for the goods and $10,000 was for the installation, then that would be a contract that's not in preponderant part for the supply of labor. It would be governed by the CISG. The CISG allows parties to opt out of the treaty. Meaning, if two parties don't want to be governed by the CISG, even if those other elements are met, they can agree between themselves to be bound by some other law. For instance, one of the major holdouts from being a CISG member is the United Kingdom, the UK. The UK has a long sales tradition and therefore has never felt the need to adopt the CISG. Well, if a country in France and a company in France and a company in China decide to enter into a contract, but neither one trusts the CISG, they can agree to be bound by the sales law of the United Kingdom. So courts will respect whatever the parties agree in terms of what law is going to govern this contract. The last thing we want to talk about is this case, Asante Technologies versus PMC Sierra. It's in your book, and I've uploaded some links on D2L for you to look at as well. This case involved a situation in which the ultimate transaction was between a Canadian company and an American company, a company based in California. And in the contract, it said that the applicable law to this contract, to the interpretation of the contract, the applicable law, this contract will be governed by the law of the state in which it was executed. So wherever the contract was executed was going to be the law that governed the contract. Well, this was a contract that was carried out over distance, and the seller of goods, based in Canada, signed the contract in Canada. The buyer of goods in California signed the contract in California, and each believed their domestic sales law would apply to the transaction. So the Canadian company believed Canadian law would apply to the sales transaction. The company in California believed that the UCC, the domestic law of California, would apply to the transaction, because that's what the contract seemed to say. When a dispute arose and the case went to trial, both parties thought and argued that their law, their domestic sales law, applied. But the court says, actually, you're both right and you're both wrong. Yes, the domestic law of California will apply, and yes, the domestic law of Canada will apply, but that domestic law is the CISG. So whenever those three conditions are met, the CISG applies, because the CISG is international law, but it's also the law that governs those types of transactions, whether the parties are in Canada or in the United States. So the main thing to come out of this knowing is that the CISG is part of our domestic law. The CISG governs any situation in which those three elements are met and which none of the exclusions apply. So in conclusion, what did we learn today? Contracting systems regulate risk distribution. The Convention on Contracts for the Sale of Goods, Unified International Sales Law, and the CISG applies to the international sale of goods. That's it. Thanks for listening, and we will start up again next time.